Okay, so this recording is a sequel to the applications to County Council lecture video, and it sets out how you appeal a decision of the County Council in a planning application to An Bord Pleánála. So appeals are set out in the Planning and Development Act 2000, which applies section 37 to provide for appeal of planning decisions by way of full rehearing. So the whole decision is made again from scratch before An Bord Pleánála. So An Bord Pleánála appeals then. Who can appeal? The original applicant can appeal, the person who wanted the planning permission. Any person who made a submission or observation in writing. So that's the prior participation requirement. Adjoining landowners who have land beside the development, only where the planning permission differs materially from that was applied for, so they didn't have, full notice of what was going to be coming. And a prescribed body who was not notified of the original application. So, for example, An Taisce or the EPA, who, in circumstances where they weren't told that the application was ongoing, but they should have been. Where the application required an environmental impact statement, any environmental organisation operating for at least the last 12 months, even if they haven't participated in the County Council stage, can initiate an appeal to An Bord Pleánála. Because there's considered to be an environmental issue at stake. So time limits then. So the time limits for making an appeal are 4 weeks from the date of making of the decision by the planning authority, not date of notification or date of receipt of the decision. So time starts to run as soon as the decision's made. It could be a couple of days before the developer knows about it or the other participants, because it will take time for it to be issued. The decision must be in writing. The appeal must be in writing. It must identify the planning application concerned, must set out the grounds of the appeal and any supporting material, and enclose an appropriate fee. Section 130 allows for observations and submissions to be made on appeal within 4 weeks of receipt of the appeal. So there's a 4-week window for submissions and observations, similar to County Council stage, where it's 5 weeks at County Council stage. Section 139 allows for appeal against conditions only, so you're not putting the whole planning permission in issue, just a particular condition like a requirement to introduce screening, landscaping or green areas. So the procedure then for appeal. So the parties to the appeal are the planning authority, the applicant and planning permission, the applicant for planning permission and the appellant. So each party then has 4 weeks from the day on which the appeal is sent to make submissions to the board, and the board can request further submissions and observations and set time limits for the receipt of them. So the board can take into account matters that were not raised on an appeal, but they must let the parties know in advance that they intend to take such matters into account, so they can take their own matters that they come across themselves into account. So Article 73 of the 2001 regs permits the board to invite the applicant to submit revised plans and drawings, so they can submit further detail to the board. So oral hearings then, I have mentioned these before, that oral hearings may happen and they're like a mini court case. So all the parties are gathered together in one room to give evidence and to ask questions of each other. And the inspector oversees the oral hearing. And not every An Bord Pleánála appeal has an oral hearing attached to it. Only where the board decides that it's necessary, and where in some cases the parties can request an oral hearing, but the board can refuse, so they have discretion, the board, as to whether this happens or not. So it doesn't happen in every case, but it can happen, and where it does, they can be very lengthy and complex. So any party to an appeal may request an oral hearing, provided the correct non-refundable fee is paid, and an appellant can request this within the time limit for making the appeal, and any other party within 4 weeks of receiving notice of the appeal. The board has absolute discretion as to whether to hold them or not. And there's 5 working days notice given of the time and place of the oral hearing, and that's not a lot. That's the minimum. They usually give much more notice than that, like 2 months notice, but they only have to give 5 working days notice. And some oral hearings for like large projects can go on for like weeks. I was at one before to do with an ESB power line, and it was, I think we were 2 weeks in Letterkenny. So doing that at 5 working days notice for community organisations or individuals whose land is affected, it's a big ask. They can be conducted without undue formality, so they don't have to follow the rules of procedure that would be applicable in court, like swearing in and all that kind of stuff, but they can do if they want to. And the level of formality depends upon the level of formality the inspector insists upon, and whether the parties are represented by lawyers or not. So when lawyers come into the room, they tend to make the proceedings much more formal. They tend to insist upon the rules of evidence and all of that. So it tends to make things much more slow and complex. Inspectors are appointed to consider each appeal and prepare a report on it for the board. So the inspector will hear the oral hearing. They will consider the appeal, whether or not an oral hearing happens in it. They will make a report on the decision. They will report to the board. The board will consider the inspector's report along with all of the other recommendations and all of the other information submitted with the application. But the inspector's report is not the deciding factor. It's not the end of the decision. If the inspector approves or refuses the planning permission, the board can still depart from the inspector's recommendations. They're not bound by the recommendations of the inspector, but they should give reasons if they go against the inspector's recommendations. The board's decision must set out reasons and considerations. This is to enable people to appeal the decision to the courts if they're not happy with it. So in O'Keefe and An Bord Pleánála, they said the requirement is what must be looked at is what an intelligent person who had taken part in the appeal or had been apprised of the broad issues which had arisen in it would understand from this document these conditions and these reasons. So what are the main reasons granting the decision? And O'Donoghue, they said the reasons must be sufficient for the court to review the decision and satisfy the parties. The board directed its mind adequately to the issues before it. So it should show the board's thinking on the decision, why they made the decision they made. And if it doesn't, that's a breach of fair procedures and can lead to the decision being quashed in itself just for that. So the considerations then that the board can look at, so the statement of considerations must therefore be sufficient to give the applicant such information as may be necessary and appropriate for them to consider whether they have a reasonable chance of succeeding an appeal, and to arm themselves for such an appeal, and to know if the decision maker has directed their mind adequately to the issues, and to enable the court to review the decision. So the time period is 18 weeks, so the board has 18 weeks to consider and dispose of the appeal. If they're not going to reach the decision within 18 weeks, they must inform the parties of this and state when they will reach decision. Unlike with the County Council, there's no outside time limit, and that means that often appeals can end up being very drawn out before the board, and this is a problem. There are huge backlogs and delays at board level, and then that leads to decisions that have been in the pipeline for too long, been rushed through, and poor quality decisions been made. There's a lot of issues there, and they fundamentally come back to resourcing. So the board being inadequately resourced to cope with the workload that they face. And, that causes a lot of appeals then in judicial reviews, and it leads to the whole system being slowed down, and the board dysfunction comes into conflict with the court dysfunction, which combines to make planning processes really slow, and projects end up being abandoned because of all the delays associated with them. And that's not because of appeal rights to the court or appeal rights to Bord Pleánála. It's because of dysfunction within the board level and the court level systems. So fees for appeal then are set out on the Bord Pleánála website. So 4,500 or $9,000 if it's an EIS application. So if there's an EIS involved. Appealing the decision of a planning authority related to commercial development, 1,500 to $3,000 if an EIS is involved. Appealing a decision of a planning authority related to an authorised development. So that's where permission is granted for development that was unauthorised, 660. All other appeals, 220. Submissions or observations, €50. And requests for an oral hearing, €50. So, they're not insignificant fees for all concerned, So there's no appeal from the decision of An Bord Pleánála on appeal. So once your appeal is heard by An Bord Pleánála, that's it, it's the end of the road. But you can review either the County Council or the An Bord Pleánála decision in the courts, but judicial review in the courts, in the High Court, is not the same thing as appeal. It's not an appeal it's not a rehearing of the decision in the way the An Bord Pleánála is. It's a review of the procedure followed in making the decision. And we'll cover this in the following two lectures on judicial review, part 1 and part 2. But suffice to say that the Article 34 of the Constitution gives the High Court the right to review all decisions of public bodies, including An Bord Pleánála and the County Council, in the exercise of their planning function. So the High Court supervises these bodies to make sure they're making their decisions correctly. So anybody can take a decision on review to the High Court to ask, was it made properly? But the High Court doesn't review the actual decision. It reviews the procedure followed in making the decision and whether that procedure was fair and common sense. And there, in that sense, the High Court are looking at did the decision-making process comply with the principles of what we call natural and constitutional justice. And we'll be looking at natural and constitutional justice in the second half of the Judicial Review lectures. So that's the process before An Bord Pleánála. And in the next lecture, we'll look at the general principles governing judicial review in the High Court. Thanks.